welcome to the webinar, Current Issues in Patenting of Agricultural Technology. My name is Adrian Bradley and I'll be one of the speakers this evening. And before we launch into the session, I would just like to introduce you to the other speakers. So on this illustrious lineup, we have Joe Gall, Dr. Joe Gall. Joe has over 30 years experience in the IP sector, both in private practice and in industry. He was a European and UK patent attorney and has worked as a senior patent attorney for Sandoz, Novartis, Zeneca and Syngenta in all areas within the ag tech industry, including small molecule chemistry, biotechnology, and professional and natural products. And most recently, he was head of fungicide IP with Syngenta. Accompanying Joe, we have Lauren Hulse, who is a partner at Holland & Hart in Salt Lake City in the US. Lauren is a US patent attorney and partner with Holland & Hart. As a practitioner, Lauren has developed, managed, and protected both large and small domestic and foreign patent and trademark portfolios. He has wide-ranging chemical manufacturing, biotech, pharmaceutical experience, which includes advising clients how to protect chemicals and formulations, including small molecule and peptide drugs, nucleotide analogues, and RNA-related technologies. And for my own part, I am Adrian Bradley. I am a European and UK patent attorney and a partner with Cleveland Scott York. My practice focuses on healthcare and agrotechnology, and I have worked as a scientist in the agrochemical sector with Zeneca, and I advise companies on patent protection issues in these fields. So it's a very great pleasure to welcome so many of you to the webinar tonight. I can see that we have attendees from all around the world. So thank you for giving up your day, your evening, your morning, or the middle of your night to listen to what we have to say, which I am sure you will find of interest. So agriculture is obviously one of the oldest industries in the world, if not the oldest, and it has been affected and shaped by technology perhaps more than any other, and arguably agriculture itself is the oldest technology used by human beings. It is still the largest industry on the planet, employing 1 in every 7 human beings of a working age. And the pace of technological change shows no sign of slowing down or relenting. And what we'd like to do this evening is to address a few of the issues that we feel are important and interesting, and hopefully stimulate a debate with the members of the audience about the direction that these changes are taking us. So you have on your Zoom control panel a Q&A box. If you mouse over that, you will be able to put questions to the audience, and I will address these at the end when we have a more free-flowing discussion. Without further ado, I will move across to the next slide if I can manage to do that. Here we go. So here's what we have on the menu tonight. We have Joe, who will talk about challenges in the agtech sector, the EU farm to fork strategy, and challenges in jurisdictions outside of Europe. I will address the topics of IP in agriculture, look at some chemical inputs and how that landscape is changing, patenting issues in Europe, including big data and biotechnology. And rounding off the evening, Lauren will discuss the US perspective, talk about seeds, automation, biopesticides, and new areas that are being opened up by these technologies. So it's a very great pleasure to welcome Joe, who I have known for many, many years and is one of the foremost, or was one of the foremost practitioners in the area. And it's a very great pleasure to welcome you, Joe, this evening. So Joe, the floor is yours.
Okay, Adrian, thank you very much for that. Can I just be sure that you can hear me properly, because I'm phoning in from rural Wales, which doesn't have necessarily a very good IT system where we are. So can you hear me all right?
Joe, we can hear you perfectly.
Right, okay, good. Thanks for that then, Adrian. Right, I'm just going to start by reminding everyone of the qualities of a successful ag tech product, such as a new chemical or a manipulated seed, which might, for example, be GM or otherwise. Some of which overlap with the requirements of IP law. So an economically viable ag tech product or process is one which reliably solves a real life problem. That seems rather obvious, but actually sometimes that is something that really can be forgotten. It must have a predictable and favourable cost of goods, including its manufacture and transport costs and factors associated with its potency, stability and formulation, for example. If we think about a GM ag tech product and the products of GM ag technology, such as a GM soybean, for example, these are very costly to deregulate. And by deregulate, I mean obtain a license for use in the environment. A favourable cost of goods for a GM product generally requires worldwide deregulation. Single market-based segregation of produce is quite risky. And deregulation usually requires complex long-term studies and submissions, the outcomes of which, particularly within a world context, are generally uncertain. They're influenced by a number of things, including ever-changing political and consumer acceptance intangibles, as well as by any genuine technical uncertainties. So an ag tech product must also, well, it preferably has a proprietary position. As patent attorneys, we of course think that this therefore relates to a patent or some other intellectual property right, but a proprietary position can be obtained via other routes as well. For example, it could be an acceptably low profit margin, or perhaps the product or process could provide a first mover advantage to establish a reputation or even a new market, for example. Of course, we don't have any way to market unless we have legal freedom to operate. By that, I mean non-infringement of third-party intellectual property rights. And of course, the product or process must comply with relevant legislation concerning, for example, health, safety, and the environment. The product must have a viable route to market. For example, a major practical challenge for the would-be ag biotech inventor concerns route to market, which is a precondition of a favourable cost of goods. Some, especially non-hybrid crops, may comprise many inbred varieties which are sold across the world by many and diverse companies. Integrating a GM or gene-edited trait then becomes very complicated. On the other hand, the problem with the major field crops, such as corn and soybean, for example, in major markets, is that the seed market is owned by too few major players, without whose generally expensive buy-in, new biotech traits may effectively be blocked. And of course, the product or process must have a societal freedom to operate or acceptance. For example, a highly effective and very specific insecticide, which comprises a genetically engineered virus, which comprises arthropod genes, which is something that a number of companies have worked on in the past, might not be acceptable, especially post-COVID-19. And indeed, that sort of product might never have been acceptable. I mean, that sort of product never came to the market for a number of reasons, and perhaps societal and freedom to operate issues, were involved there. Next slide, Adrian, please. Possibly some of the biggest challenges in the ag tech sector relate to the increasingly stringent aspects of legislation concerning health, safety, and the environment. For example, the European Union Green Deal sets what, in my opinion, are admirably high health, safety, and environment standards. The EU Green Deal is the Commission's plan to make the European Union's economy sustainable by turning climate and environmental challenges into opportunities. It provides an action plan and a set of policy initiatives which are aimed at boosting efficient use of resources by moving to a clean and circular economy, whatever one of those is. It sets out to make Europe the first climate neutral continent by 2050, and it contains numerous strategies and plans such as the Sustainable Europe Investment Plan, the Circular Energy Plan, and the EU Biodiversity Plan. It also comprises the farm to fork strategy for a fair, healthy and environmentally friendly food system. I'm going to refer to the farm to fork strategy a number of times as I go through this talk, and therefore, just to make it easy for me, I'm just going to refer to it as the FTFS. I'm going to run through this FTFS rather quickly, and I'm going to try not to comment too much on specific aspects, although there are one or two that I know I won't be able to resist, making a comment on. I think it's difficult to criticize the FTFS's many desirable objectives, but the targets for achieving them seem to me to be a bit naive. And I wonder how, in the absence of concrete tactics for achieving them, they can actually be met. But I suppose time will tell. Next slide, Adrian, please. So, as indicated in the last slide, the FTFS is at the heart of the Green Deal, and it aims sustainably and competitively to reduce dependence on pesticides and antimicrobials. It aims to reduce overall use and risk of chemical pesticides by 50% and the use of more hazardous pesticides by 50% by 2030. It will revise the Sustainable Use of Pesticides Directive. It will enhance integrated pest management, and it will restore soil health and function and promote crop rotation and mechanical weeding as a way of controlling weeds. I'm just going to make a very quick comment on mechanical weeding, because mechanical weeding can damage soil structure and adversely affect soil health. Herbicides and burn down agriculture play a big part in maintaining the structure of arid soils and their organic content by minimizing tillage. It may not generally be appreciated, but this is a genuine environmental plus point of non-residual herbicides. So there's potential opportunity to invent new non-residual herbicides and crop resistance products. But in practice, such opportunities would likely require a GM component and likely this only be viable in a global crop market. In addition, in order to be economically viable, they'd probably also require worldwide deregulation. Anyway, back to the FTFS. It will promote pesticides containing biological active substances as opposed to chemical, in inverted commas, active substances, and it will reduce the length of the pesticide authorization process. I'm just going to make a very quick comment about biological active substances. Although there are a few notable exceptions, for example, Bt toxins, non-GM bio-based products such as natural products and mixtures of oils and bacterial and or fungal extracts, etc., have generally been less effective, less reliable and less homogeneous than those containing more classical chemical actives. So natural or biological pesticides or crop enhancement products have a track record of being niche, overly species and timing specific, unreliable and difficult to formulate. Hitherto, they are the kinds of products which can be said to provide for up to a certain level of improvement in up to a certain percentage of the plants to which they are applied and subject to any other conditions. At the moment, accepting less optimal yields per acre in the European Union is what presently such products are likely to provide for. But this is also likely to create a demand for more land overall, possibly even indirectly via imports, which could translate to a reduction in the non-farming environment that could otherwise be rewilded to meet species loss and/or diversity targets. The FTFS will reduce excess fertilization. It aims to reduce nutrient losses by at least 50% whilst ensuring no loss of soil fertility. It will reduce the use of fertilizers by at least 20% by 2030. It will improve the management of nitrogen and phosphorus through the production cycle. There will be an increase in organic farming. The target of the FTFS is that 25% of European Union agricultural land will be organically farmed by 2030. There's going to be a significant increase in aquaculture, which is seen as a considerably more environmentally friendly way of producing food than the use of land. The FTFS will also improve animal welfare. It will reverse biodiversity loss and reduce air, soil and water pollution, and also reduce greenhouse gas emissions. Animal feeds are to be replaced by those that contain proteins from European Union grown plants, proteins from insects and protein from marine food stocks, and by byproducts of the bioeconomy such as fish waste. The FTFS will reduce food waste and reduce, or at least reverse the present increase in obesity by 2030. And there are a number of ways that that's going to take place, apparently, including the reformulation of food products. The FTFS will set new marketing and advertising standards. For example, food price campaigns will not underestimate the value of food. And the FTFS will deter the use of marketing campaigns which advertise meat at very low prices. It will encourage a move towards a plant-based diet and away from red meat. The FTFS will apply a system to ensure that food prices properly reflect its real cost in terms of the use of the planet's finite resources and the production of pollution and greenhouse gases. I would imagine that would perhaps involve an increase in prices of some of those types of food. It will halve the per capita food waste at retail and consumer levels by 2030. At present, it's estimated that about 20% of food within the European Union is wasted. It will deal with the misuse and misunderstanding of date marking, for example, concerning best before and used by expressions on supermarket products. The FTFS will reduce antimicrobial resistance in farm animals, and it's further spread into humans. For example, it's estimated there are 33,000 deaths per year in the European Union associated with inappropriate use of antimicrobials within an agricultural context. The European Union sales of antimicrobials for farm animals use and in aquaculture will be reduced by 50% by 2030. There's going to be a reduction in food fraud, and the FTS will also improve internet access to all farmers in all European Union rural areas, and specifically there's going to be 100% fast broadband access for everyone by 2025. I don't know what fast broadband access means, actually. Next slide, Adrian, please. So, as you can see, the FTFS provides a large number of challenges and problems for the ag-tech sector in the short to medium term. Many practices which are central to the European Union ag-tech sector and food production sector, which function well enough at the moment, will be diminished or at best overhauled with a large degree of uncertainty. In addition, the FTFS includes many targets for improved food production and animal and human health and environmental remediations and improvements, which will require new ways of doing things and the possible application of yet to be invented technologies and products. The Green Deal and the FTFS firmly place its faith in research and innovation, which is something that will make it successful. The European Green Deal, this has been an issue that's been revived recently, I understand, may transform the European Investment Bank into the European Climate Bank by preferentially funding green projects. It contains a mechanism, or at least a hope, I think, to support industry to innovate in order to achieve its objectives. Potential areas for FTFS-favoured research and innovation include the bio-based economy, and in particular biorefineries, which produce biofertilizers and protein feed, bioenergy and biochemicals. There will need to be improvements in or relating to anaerobic digesters. For example, biogas, meaning likely methane, will be produced on an enhanced scale from animal and food waste and waste from the beverage industry, as well as sewage, wastewater and municipal waste. Farmers, in particular, are envisioned to play an increasing role in dealing with such waste. The FTFS will encourage the use of biotechnology. Now, I don't know what this means, but I doubt that it relates to the wholesale acceptance of GM crops, or possibly even gene-edited ones, if you want to exclude the presence of transgenes. Bear in mind also that gene editing is very unlikely to provide for the full repertoire of traits which could be provided via a transgenic approach. So bio-based products will be encouraged, as will the use of new genomic techniques to improve sustainability along the food chain. I expect that such new genomic techniques still have to be discovered, however. Next slide, Adrian, please. So there is going to be some specific money available from the European Union to help achieve these aims and desires of the FTFS. 10 billion euros is going to be available under Horizon Europe on a number of broadly defined subject areas, including food from the oceans, urban food systems, the microbiome, and the provision of plant, microbial, marine, and insect-based proteins as meat substitutes. Next slide, Adrian, please. I just want to mention very briefly, towards the end of this talk now, a couple of other territories. So I'll mention China, Brazil, and the US. The central government in China has hitherto been reluctant to promote practices which reduce food production, even if they benefit the environment and increase profit for farmers. And this has favoured the traditional, relatively intensive ag-tech, meaning non-biological small molecule chemistry approach, and the newer transgenic approaches. However, I think only perhaps a few weeks or even a couple of short months ago, President Xi Jinping announced his intention that China will be carbon neutral by 2060, which may improve Chinese farming practices as well as emissions from Chinese heavy industry. In terms of Brazil, intensive, generally environmentally unfriendly and unsafe farming practices, which have included transgenic and traditional ag-chem techniques, can lead to rapid deforestation in the humid tropics. Brazil still uses at least 10 types of agrochemical product which are prohibited or otherwise not registered for use elsewhere. In terms of the US is perhaps more liberated than certain other territories in its use of new technologies and has embraced transgenic and otherwise genetic manipulation, for example, but it still recognizes the benefit of traditional agrochemical solutions. In fact, like Brazil, the US still uses certain agrochemicals which are banned elsewhere in the world. At the moment, the present ag-tech solutions to food production problems in at least China, Brazil, the US and Europe are to a large extent transferable, which is obviously advantageous from the point of view of the research-based ag-tech industry. But this is likely to change in the future with ever more stringent HSE legislation. Next slide, please, Adrian. So in summary, worldwide population growth coupled with rising incomes has led to the consumption of higher quality foods, including meat, and that's created higher consumption of feed crops, including soy, maize and wheat. And at the same time, the total acreage of arable land available for producing crops is under pressure from a range of forces, including growing populations, urbanization and global warming. These trends are driving the need for higher agricultural yields, which has resulted in an intensification of farming. And in order to reverse what are seen as the negative environmental and human and animal consequences of such intensification, new regional health, safety and environmental strategies are being developed. A lack of worldwide harmonization on HSE issues creates uncertainty for the global ag-tech industry and may act as a disincentive actually to privately funded research and investment. So the new HSE standards, or the new proposed HSE standards in Europe, will likely diminish markets for existing agrochemicals and new agrochemicals which are of a similar type. And as I mentioned, this is particularly true in the European Union, but there may be a knock-on effect elsewhere. For example, it may be that demand diminishes in the European Union for food products which are produced outside the European Union more cheaply, but at a greater cost to health, safety and the environment. So new products and processes are needed which will satisfy, for example, the FTFS and are effective and are sufficiently economically attractive to justify the huge amount of industrial research and investment likely to be needed in order to be able to achieve them. So as I've said in the last sentence here, I think, our scientists need to get back to their laboratories and invent them.
Thank you. Thank you very much, Joe. So we'll take questions at the end. So if Joe's presentation has spurred you to ask a question, please put it in the Q&A box. And I will mute Joe. Don't be offended, please. There we go, mute him. And I will seize up the mantle. So as Joe has eloquently set out in his discussion, agriculture is and always has been by its nature a technologically intensive sector of human activity. And arguably one of the earliest inventions, the plough, the moldboard plough, enabled people to devote less time to agriculture because it improves efficiency and enables people to develop human culture. So it's an extremely important area for innovation. And one of the innovations that I want to talk about to set the scene is the one that I have shown here. And I'm telling the story because it illustrates not only how technology affects agriculture, but how this technology shapes the nature of an industry and indeed the nature of a continent. So the invention is obviously barbed wire. And in 1874, there was a patent competition. There was a race. There was a number of different patentees who were seeking protection for inventions related to barbed wire. But the one that was ultimately successful in the marketplace was by Joseph Glidden of DeKalb, Illinois. And prior to the invention of barbed wire, if ranchers wanted to fence their livestock, it was made out of wood, which was extremely expensive in the west of the United States because the wood had to be imported generally from the East Coast. And also it was very poor at its job because it broke and allowed the cattle to stray. So the invention of barbed wire changed the West permanently by limiting the open range, enabling ranchers to section off and parcel up the land. And this completely changed the nature of agriculture in the United States and in particular in the West. And by dividing the land in this way, completely changed the landscape. So as Joe has mentioned in his speech, there are a number of drivers for agricultural innovation. There is obviously the demands of society, first and foremost, to be fed with a diet that is nutritious and ample for their demands. There is the legislative landscape, which regulates and incentivizes or prohibits certain technologies from being adopted. And as was clear from the previous speaker, these differ from country to country, in particular with regard to the adoption of transgenic organisms in agriculture. And there is technology that emerges and will address some of these emerging technologies, in particular automation and big data, and see how those are changing agriculture and consequently changing the intellectual property landscape that we're existing in. As Joe mentioned in his talk, chemical inputs, namely classical agrochemicals, are popular and widely used because they are efficacious and proven. They generally work. And the market is still a very large one. So various eye-popping figures are quoted, but I think of 50 billion is of the correct order of magnitude. There is still a large amount of research and development work which is being conducted on such products. But I think it's true to say that the demands that are placed on new products are ever more stringent in terms of their environmental profile, their application rates, their efficacy, the changes in agronomic practice, cost of goods, and more stringent regulatory processes. All these factors lead to the result that new actives are increasingly expensive to develop, and consequently fewer new, genuinely new active ingredients are introduced into the pesticide market every year. This has been partly offset by the introduction of new products which are combinations of known actives or known actives and safeners into the marketplace to fulfill unmet need by growers. We often talk about the patent cliff that is faced by the pharmaceutical industry, and this is no less of a phenomenon within the agrochemical sector. So I've shown here some of the products which are due to lose patent protection within the next 5 years. So there are some very big selling products on this list. This is, of course, a reason for companies to continue developing new products, and this is part of the quid pro quo, after all, of the patent system, that people have the time-limited monopoly to exploit, and then the invention is available for others to use. So it's necessary to have this balance. The patent system is, after all, a balance between innovation on the one hand and access on the other. The balance between innovation and access that I mentioned is not a static one. It is dynamic, and it is always being tweaked and adjusted, and people on both sides of this seesaw are responsible for adjusting this balancing point. But as I mentioned a couple of slides ago, there are fewer bigger products which are entering the classical agrochemical space. And these products are more expensive to develop and are subject to more stringent requirements from regulators. So this has led to a demand for increase in patent term, no less than in the pharmaceutical industry. The regulatory process for launching a new agrochemical onto the market is very, very time consuming, and this erodes the effective patent term, which the patentee is enabled to benefit from his monopoly. And as we see in other sectors, this has led to lobbying for increasing patent term to compensate for these regulatory delays. And it has also led to the construction of the so-called patent thicket, where proprietors seek to prolong their monopoly through follow-on inventions relating to isomers, salts, polymorphs, modes of application, combinations of active ingredients in to extend the monopoly. And with my patent attorney hat, of course, some of these represent genuinely beneficial innovations and are of overall a valuable contribution to the agrochemical market. But all of these things make it more challenging for generic products to enter the market on expiry of the active ingredient patent. One way that the legislators have sought to compensate agrochemical companies for these regulatory delays is through patent term extensions. So in Europe, there was originally a system of supplementary protection certificates that applied to medicines, but this was subsequently expanded to include crop protection products. Similar SPC-like extensions exist in Japan, South Korea, and Taiwan, whereas patent term extensions are available in the countries that I have listed here. So an SPC is not a genuine extension of the patent per se. It is rather a right in and of itself, which is a where the intersection of the marketing authorization and the patent protection exist. So in terms of SPC case law, a lot of this has centered around the question of whether a product is protected by a patent in force. So one of the requirements for obtaining a supplementary protection certificate is that the product, as defined, is protected by a valid patent that is in force. In Royalty Pharma, the decision by the CJEU affirmed that the grant of an SPC for a product that falls within the general functional definition used in the claims, but is not individualized, is not in principle precluded from protection by a supplementary protection certificate. So I think it's fair to say that most of the case law in the SPC field does relate to medicinal products, but there are occasional decisions which are handed down by the CJEU in the field of crop protection products. And the one I've listed here, C11 of 13, relates to whether a safener, isoxadyphene, could be protected by a SPC. An issue that is current but has not yet been resolved is whether it is legitimate for third parties to obtain SPCs, that is, extensions of their own patents based on marketing authorizations obtained by someone else. As I've mentioned, a bigger and bigger area is combination products in the agrochemical sector. And this brings into focus a doctrine which has risen to prominence at the European Patent Office. And it is the requirement that the invention is made plausible. What this essentially means is that there be sufficient data present in the application as filed that a skilled person can conclude that the patentee was in possession of the invention at the time it was made, to render it credible. And the intention behind this is to prevent the filing of purely speculative applications. So in the field of combination products, what you are almost always looking to provide is evidence of synergy. And that evidence must be present in the application as filed. Otherwise, the application can be invalidated either on the grounds of sufficiency or inventive step. So this is something that applicants need to be aware of, and obviously if you are on the other side of the fence, challengers can make use of. Big data is affecting every area of contemporary life, and agriculture more so than many other areas. There is now an unprecedented level of automation in agricultural production, and the degree of precision agriculture that this affords. So using a combination of satellite imagery and drone data, farmers can get an unprecedented amount of information on the fertility and other characteristics of each field, really down to a very precise level of granularity. And these technologies where we're analyzing this kind of data and obtaining this data, it is classic space for patents, obviously. All this generates huge volumes of data, which is of use not only to the individual grower, but potentially much more widely. And a vexed question is, who owns these data? So some providers of these information sources have as part of the license to use the technology, they have access to all this data, which is enormously valuable in not only to the individual field, to the individual farm, but in aggregate. So it's an interesting area of intellectual property law. Who owns the data relating to these individual analyses, to these individual topographic correlations of fertility, etc. So, as Joe has mentioned, the climate with regard to genetic modified organisms is not favorable from a legislative perspective in Europe. And the instrument which governs all of this is kind of getting old now. It's nearly 20 years old, and some people would argue it is not really any longer fit for purpose. So it relates to the prohibition on the deliberate release of genetically modified organisms into the environment. And there was a decision a couple of years ago which examined the question of whether organisms obtained by mutagenesis rather than transgenesis, for example by CRISPR technology, should be regarded as genetically modified organisms. And in the view of the CJEU, these were to be treated as such genetically modified organisms. The last topic I want to address is patenting of breeding techniques at the European Patent Office. The operative instrument is Article 53 of the European Patent Convention, which sets out exceptions to patentability, including plant or animal varieties or essentially biological processes for the production of plants or animals. And this question has been revisited a number of times at the European Patent Office. And two decisions that were handed down in 2015, referred to as Broccoli and Tomatoes 2, determined that although essentially biological processes, that is natural sexual reproduction of plants, the processes themselves could not be patentable subject matter in Europe, but plants obtained by such processes could be, however, patented. Subsequent to that decision, the European Parliament asked the Commission to review the patentability of plants and animals derived from essentially biological processes. And the European Commission issued a notice clarifying that the EU legislator, when framing the Biotech Directive, had intended to exclude such plants and animals from patentability. And earlier this year, a further decision of the enlarged board was handed down. And the salient point is that this reversed the earlier G decisions, G12 of 12 and G2 of 13. And there was a change in the thinking of the enlarged board, and in essentially biological processes and plants and animals obtained by those processes are no longer available, patentable before the European Patent Office. So I will stop there and hand over to our final speaker of the evening, who is Lauren Hulse. So Lauren, the floor is yours.
Thanks, Adrian. I think I was able to unmute there. I appreciate you the time. And I'm glad to speak to this topic. I wanted to kind of give a broad overview of trends and directions that we're seeing in IP in the agricultural area broadly in the United States. Adrian, if we could bump to the next slide. First, this time of year is one that I think many people, at least where I live, turn back to agriculture. It's seen by many as their roots. It's seen by many as tradition. And so there's a lot of time spent on farms, at corn mazes, at pumpkin patches in the fall. Several of these are local attractions in the pictures that I have there. I think many, however, don't respect and don't realize the amount of technology and amount of investment that go into this industry. Next slide, Adrian. So the USDA, and these numbers are a couple of years out of date, but it still is mind-boggling, the huge amount of money that is pumped into the United States economy, as just a single example, by the bio-based products industry. And even more perhaps startling is the huge effect it has on employment. That on the print on the little bubbles there is small, but there's a jobs multiplier. For every 1,000 bio-based products jobs, 1,760 additional jobs are created and supported outside of that industry. So this is an incredibly critical area that is interesting because it's changing, and how it's changed a lot in the past decades is how it's supported. And then this has affected both the directions of food generally in the society, but also the industry broadly. The next slide, I mentioned that typically and traditionally, much of the research in this space in the United States was supported by public funds. So in my state, agriculture is huge, and we have universities that were founded as agricultural universities. They were meant to study agriculture. I grew up in the shadows of a farm that studied orchard cultivation of different fruits and mostly fruits, and I grew up driving past this orchard, this series of orchards, multiple times a day, watching as year to year trees would be cut down, different pruning techniques would be attempted, different cultivars would be tried. And these universities still function, but their funding has been greatly reduced in previous years, and much, much more effort now is put into food development by the private sector. So it's now become an area of massive private investment as opposed to public. And in recent years, this has resulted in interesting changes in the economy and the industry, including huge consolidation. Where decades ago there were 60 major seed producers. Now about 60% of the market is held in the hands of 4 different seed producers. I wanted to hit a couple of specific areas in the U.S. First, seeds. Next, technology on the farm, and last, novel markets. And we can talk about each of those in point. Adrian, if you could bump to the next one. Seeds were kind of an early battleground in the area where there was a lot of fighting and discussion, and that has calmed somewhat, though enforcement still continues. Many are familiar with the Bowman decision, where a farmer to get seed stock for a late crop would purchase seed that had been mixed with other seed intended to be used as feedstock. And he would purchase that seed, plant it, hoping that there'd be enough Roundup Ready gene in there that he could get a decent second late crop out there as, again, a risky later crop. He would plant that, and was discovered eventually by Monsanto and sued. And the Supreme Court eventually held that, yes, indeed, that activity was infringing, which the issue that he'd hoped to hide behind as this became to be a problem was the fact that the first purchase should exhaust the patent. In self-replicating inventions like this, the court held that no, indeed, the exhaustion doctrine did not apply, and the seed could not be used to grow new seed in that way. So since then, the value of those crops have continued to be a huge part, again, of the economy, and have been estimated to contribute to global productivity in a very, very significant way. The effects, though, I don't see as much litigation around seeds currently, but there is worry that there is chilling by the big manufacturers. of additional innovation. On the next slide, you'll see that, sorry, again, the consolidation point that I noted, enforcement efforts continue, and as I've spent time researching and reviewing the subject, I saw over and over small organic seed producers, small companies that try to avoid GMO in any form, are receiving on a regular basis, sometimes as frequently as yearly, just watch and notice letters from the big seed producing companies to put them on notice that our seeds are patented, stay away, be careful. That I was troubled in reviewing these publications and doing this research, that I began to see a trend of chilling as researchers would get notice of, say, one example that was given was a high lycopene carrot that was a deep red color because of the increased lycopene. They were put on notice of a competing plant patent that had similar properties. And because of those properties, and because of perhaps even a misplaced fear of patent infringement, 2 or 3 different research groups stopped their work in the area and moved along, worried that they would be developing something that would be found later to be infringing. So that is one area where ethicists, society, and ethics are conflicting and debating the issue a lot right now. In recent weeks, I saw the next one on the page, and the graphic that you'll see off to the side, which, forget the small print, this is a package of carnival grapes, which are a very sweet grape product, sold at a little bit of a premium because they're patented. And on the packaging, it says, the recipient of the produce contained in this package agrees not to propagate or reproduce any portion of the produce, including but not limited to seeds, stems, tissue, and fruit. So you, the consumer, going to the grocery store and purchasing grapes, are now subject to an end user license agreement if you buy these grapes. That is unusual. I've not seen enforcement extended out to the end user at that point. And I'm curious to see how that will play out as that is, to see if it, 1, becomes more common, and 2, if it's challenged in the courts over time. So with seeds, again, I think we're in a little bit of a holding pattern. Changes pick up, however, moving to the next slide, when we get into technology, more of high technology on the farm. And this is an area that I think traditionally has not been looked at, but is now the subject of a huge amount of innovation and a huge amount of time, effort, and investment, where patents to sensors and management systems are becoming very common. And farmers are in possession of products that can allow them to track every corner of their farm, to know soil moisture content, temperature, water monitoring, air monitoring, and in other systems, they can watch for pests and see the concentration of a specific pest in a specific area, the frequency of trapping in another area, and automatically dispense chemicals to disrupt breeding cycles or to attempt to poison insects as they go, allowing the farmers to record and visualize pest populations across the farm, but also, as Adrian mentioned, creating a vast amount of data that a farmer needs to be aware where it's being held, how it's being held, is it being kept, and what rights are they losing and or keeping to that data. That's an interesting space, and one that, as in many other areas, farmers are realizing their data can be lost if they're not careful in tracking the agreements that they're using. But also, they need to be watching that now in perhaps new ways, they're generating trade secret information that they've not had to track and protect in any other way before. As they develop software, as they track, as they deploy AI and machine learning systems across their farms, they may be generating innovations of their own that should be looked at for patentability. This is a new space. This is not something that has needed to be looked at before. Similarly, robotic assistance, moving to the next one, is a complete new area. There's hope that it will solve some of the labor shortage problems that have been regarded with concern for years across the industry. But there's also questions about it. The hope and trend initially the trend initially was to large automated machines that would go across the fields, compact the soil, sometimes cause problems of their own. I'm beginning now to see movement towards smaller swarms of smaller machines that run autonomously, are aware and mindful of other human workers in the fields, and can safely avoid them, but hum along doing their individual tasks without a lot of human supervision. Several examples include this cute, charismatic little HV100 that I took the picture of here, that can move stock around, taking the place of workers in increasing their safety, and do so entirely autonomously. There are the last thing I would have expected to find, autonomous berry pickers that have robot arms that individually go and select a single strawberry for harvest, one at a time, place it in a hopper, picking them only when they're ripe and leaving the rest to ripen on the vine. Autonomous bug vacuum systems, again, to avoid some of the chemicals and pesticides that have begun to fall into disfavor, that can autonomously follow the furrows in a field and vacuum the pests off of the plants individually, and can do so without supervision. Further, let's roll down. Another space that is perhaps one where you will see more of an issue from the patent perspective with recent myriad cases, is the biopesticide space. And this is one that's very interesting and a little fraught, where companies are hoping to, in several ways, get around the traditional chemicals by looking to more bio-based solutions. In some, they're deploying natural predators or naturally toxic agents, such as counter microorganisms to counter infections. The example I've got here is from Marone Bio, and that's where this lovely photo of the blooming alligator comes from, where they deploy under perhaps the first bullet microbial pesticides there, Comobacterium subsugi, I believe is how you pronounce it. It's toxic to a variety of beetle larvae, stink bugs, corn rootworms, and moths. And by deploying that naturally, that can counter infections and counter pests. There are also pesticidal genetic material that can be applied, and then biochemical pesticides that are naturally occurring substances with pesticidal qualities. These are a little bit difficult from the patent perspective in view of the recent myriad decisions. I guess it's decreasingly recent in the United States, barring the protection for strictly natural combinations. So as I've watched these patents, it's interesting to see the efforts of the patentee to attempt to get around and to seek strategies for seeking protection. You may not be able to protect the composition itself if it is wholly natural, but you may be able to protect methods of its use, methods of application, and again, if there are non-natural components that would not be obvious combinations, you may be able to get protections to the composition itself. But that's an area that's very much developing in real time and very much subject to recent case law and strictures. So that's an area to watch and an area that's growing very quickly. Lastly, I want to discuss the last phenomenon, one that I'm seeing a lot of patent activity in, is substitutes for meat products. As Joe mentioned and others, there's a lot of pressure to provide meat, which is difficult and which is hard on the environment, more difficult to provide, more expensive to provide. So there's been a push by several companies to get into the plant-based meat replacement area. And there's a lot of work in this. And these patents, reading them, they read like biotechnology patent applications, complete with sequence listings and very complex claim structures. The first one here that was granted in mid-2019, as you read it, it calls itself not only a food product, but as you read through, this is very much a chemical composition, as emphasized by the piece that I could not include on this slide, which is the last piece, the last phrase, after D, speaking to one or more plant proteins containing no animal products that contain heme, you have a list of about a full column and a half of a patent application of different chemical compositions that could be present from the selected group. Very complicated, very involved claiming strategies, and not always successful. looking to the next slide, beyond meat. And I do believe this is the first time I've seen hamburger as a figure in a patent illustration. This patent is still stuck before the patent office and deeply in prosecution, and not even speaking of itself as a food product anymore, as several different claim sets have been tried and rejected and deleted and started over. It's now an agent release system that attributes a meat-like attribute to a meat-like. I ran out of the times I had to retype meat-like in these claims. So this is another and perhaps the last area to talk about today, where this will also drive not just innovation, but it will also drive the types of crops that are planted and harvested, and how our lands are used in many years to come as these products achieve adoption by the public. Lastly, another issue that was hit on briefly earlier is non-animal protein sources, insects. And this is another area that is attracting a great deal of investment and innovation. This particular company mentioned here, has attracted hundreds of millions of dollars to build huge insect farming factories. The first one that was mentioned was in France. So the rest of the world will be watching as this effort progresses as well. Adrian, those are the comments I had today. I'm curious to see what questions and other comments have come in.
Thank you very much, Lauren and Joe, for those excellent expositions. I'll just unmute everybody. Joe, if you could unmute, then I'll throw the floor open to questions. Joe, I had a question for you. You talked a lot about the farm to fork strategy in the EU and the goals and how ambitious they are. Do you think they've they're spreading themselves too thinly? Would it have been better to focus on a couple of priority areas rather than trying to address so many at the same time?
Well, I don't think all of them are to be addressed at the same time, because there are a number of aims which are to be met at certain time intervals between now and 2030. So some issues will need to be progressed by 2023, others by 2025, and others by 2030. I have to say, however, that I do think that the aims are incredibly broad, and only time will tell whether or not any of them are really met, never mind all of them. Yeah.
I mean, I personally, I see a tension between the goal of having more organic farming and environmental objectives, because less intensification of farming necessarily means more land under the plough, I would have thought, unless the other speakers can tell me differently.
No, I think that's absolutely true. And in fact, it is one of the issues that has been mentioned specifically in the European Crop Protection Association's position paper on the farm to fork strategy. So I think you're absolutely right. I mean, how that will be solved, well, once again, time will tell.
Okay, we've got some questions coming in from the audience. So we have a question from Monique Simmons. Do you think that natural product discovery as leads has had its day? Perhaps I'll address that to Joe in the first instance.
Well, who knows, right? I mean, generally speaking, it hasn't been terribly successful in the past. That's not to say that it might not be successful in the future, especially bearing in mind the new incentives that are provided by the farm to fork strategy. I mean, there have been some good natural products, as I mentioned. BT toxins in particular, have worked very well and continue to do so. So I can't say that they've had their day, but what I can say, actually, I think, is that they have generally not been as reliable as traditional agrochemical solutions. And I think one of the things that farmers and organizations, in fact, like to have is reliability. So I'm not saying by any means that there won't be something in the future, but generally speaking, I wouldn't have thought it was a wonderful area to spend too much time in FL on.
I think Monique's question more related to natural products as leads, maybe in a discovery program. So there are some outstanding successes in the agrochemicals area where there has been a natural product which was not itself suitable as a plant protection product, but which has subsequently been developed. I'm thinking about the strobilurins and the pyrethroids in particular. They're very important classes of product, and I think there will be as potential leads. I think they are a very productive source of new areas of discovery.
Yeah, I think that's true.
I can concur with that, Adrian. If I could just briefly, as background, I used to work for a drug company whose tagline was "Drugs from Bugs." They were looking to animals that had neurotoxins or neuroactive agents that they wanted to turn into pharmaceuticals. That effort was not 100% effective and successful, but I do think that natural sources are continuing to provide innovation and product opportunities. That Marone Bio Innovations company that I mentioned, several of their active products are simply a bacteria or an extract from a fermentation of specific bacteria that is applied to crops as an insecticide or as a fungicide. So when you look at the active ingredient, it lists a specific bacterial strain, and that's it. So I do think that's an area that will continue to get a lot of attention as this space continues to evolve.
I agree. We've got some very provocative questions coming in from Aida Rendon. So Aida demands to know, the food market is also monopolized by the patent owners and the distributors such as Walmart, Costco, and other big supermarkets. Is that right? Joe, you are required to separate right from wrong.
I'm glad it's Joe doing that.
I don't think so, no. No, that's my personal view. No, I don't think that's right. That's all I'm going to say on that.
It's a couple of times we mentioned that the seeds market is now so concentrated, and I think that is potentially an undesirable position.
Yeah, I can agree with that too. As that continues to concentrate, I worry about the need for diversity in the space. I've read and watched the drama around the Cavendish banana, the banana that you see in the grocery store most typically, and how it's begun to struggle with blight, and plantation after plantation topples because we're reliant on a single variant of this food product.
Yeah.
Diversity is important.
Yeah, agreed. I have a very interesting question here from Martin Ullman. Who owns the data? Is it the farmer or the solution provider? How to tackle this from the solution provider point of view, as our intention is to own the data? Very provocative question. Lauren, would you please address yourself to it?
Absolutely. I think if your intention as a solution provider is to own the data, you'd need to be very upfront about it to avoid anxiety, to avoid stress, to avoid the farmers feeling like you're playing a game of gotcha with them. It may be that the farmer and the industry would be comfortable with you owning the data, but agreeing to only use it in a way that gets rid of any attribution, that anonymizes it, and that makes it part of a large data set to prevent individual farmers feeling like they could be singled out, called out, or identified in the future if there's a problem in their farm based on the data sets that you're holding.
Yeah.
On the other hand, I'd want to make sure they felt like they could access and get to any data that they wanted to see that you gathered. I would think those are the rights and the rationale they would want to see.
Is it interesting from an IP perspective? What right are we talking about? Are we talking about copyright? Are we talking about trade secrets? What are we? You know, it's important to establish what we're talking about in the first place.
Fair question. I think my initial thoughts go to trade secret. If I, using data that's gathered on my farm, determine a dosage regimen, for example, of a specific herbicide or fungicide or something else that can results in an increased output, and that's something that I find when I try elsewhere, again under controlled conditions, that could be useful, I'd want to be able to keep that to myself. And if you, who have the sensors all over my farm and helped gather the data that helped me notice that, if you have rights to it, then do I hold a trade secret truly? Probably not.
And Joe, what's your feeling on that?
In the agreement.
Yeah, I think. I mean, I tend to go down the trade secret, route myself, actually. But of course, once something is, it's difficult to keep things as trade secrets, actually, in a way in which you might want to use the the products of that information. So, I mean, I think the best way to deal with this is via contract, and to make sure, as Lauren has said, that everyone knows their rights and responsibilities at the outset by provision of a suitable agreement.
Yeah, I mean, I read that some years ago, in 2015, about 30% of the agricultural land in the US was subject to this kind of intensive data collection, and surely it's more now. So it's a hugely valuable asset. And in the same article, it estimated that by 2020 the agricultural data industry would be worth $5 billion. So it's big business.
Absolutely.
Yeah. But as always, when a new technology emerges, the law struggles to keep up.
Yep, we'll get there, but it takes a while. You're very right.
Okay, we have another question from the prolific Aida Rendon. Insects are largely eaten in Mexico. They are just proteins, but could not see the way to patent them as food. How could this be? So the patentability of insect-derived proteins. So Joe, have you ever eaten an insect?
Well, I probably have, actually, in my breakfast cereal, but not recognized it as such. And I think that's probably true for a lot of people, actually. Mm-hmm. So, I mean, a new use of a known material can be itself a patentable invention. I'm not suggesting that the eating of insects is at all new, so that wouldn't be a patentable invention in its own right, but the way that they might be processed, for example, could help add some degree of patentability, or a particular application. I mean, because not all insects presumably will be equivalent. There will be some insects that are actually better than others for dealing with a particular issue. So I could see that there might be aspects of patentability associated with the use of insects as food products, or at least the processing of such insects, or the mixture of such processed products with something else, for example, which might help stabilize the products or something like that. So I can see that it might be possible to patent aspects of using insects as a food material, notwithstanding what's already known.
No, absolutely. I think if the product fulfills the requirements of novelty, inventive step, and sufficiency, then it's as patentable as anything else potentially.
Yeah, absolutely. We're seeing cricket flour-based protein bars hitting the market here in the United States. I don't see they're not widely distributed yet, but things of that nature are certainly something you could consider for patent. Transgenic animals, if you can GMO them to be more prolific, easier to grow and raise, that could certainly be patentable here in the United States. Yeah. I think there's a lot of room for that.
It's only a few years before Soylent Green comes on the market, isn't it?
Yes, the company I mentioned, I think their first effort is going to be in aquaculture to replace and improve fish food as a first step, but they do have humans on their list. So
I have another question here from Antonio Puertas Bonacella. And Antonio asks, according to GE3 of 19, can a special tomato obtained by biostimulant input be protected by patent in Europe? Joe, I guess we should thrash this one out between us. Do you want to have the first stab?
No, I'll let you go first, Adrian.
Thank you very much, Joe. That's extremely courteous of you. I would say the G decisions, what is prohibited is the natural sexual reproduction step. That is, as I understand it, at the crux of those decisions. So it would depend on whether such a step was involved in your hypothetical tomato, Antonio.
Yeah, well, I go along with that.
Excellent. Okay.
Thanks.
And we have a question from Leonor Galval. So she says, great panel, which is a very kind of Leonor. Thank you and congratulations. Joe, in your experience, how do companies manage a global IP strategy in a technology field in which many of the most relevant countries have such varied IP legislations for agricultural products? Do you keep mainly US and EP laws in mind when devising the main protection strategy? Excellent question, Leonor.
Right. Well,
you're mentioned by name, Joe, so there's no wriggling out.
Thank you. Thank you.
That's
Thank you for that. Right. Thanks. What we would like to have, in fact, is a product which is equally applicable around the world, and then we will take into consideration, obviously, the IP laws of the various countries. Now, obviously, some of these IP laws differ, as has been mentioned. However, what we do more often than not, actually, is to look at the major markets, and we take into consideration the relevance of the product to a particular market. Now, it used to be that we would consider, in particular, perhaps 10 or 15 years ago, the US would be a major market, and that would be our primary concern, along with Europe. And the IP laws between Europe and the US were sufficiently similar to enable us to, have perhaps one product or a product that was only minorly modified for each of those markets. However, we have also taken into consideration in the last 10 years or so, the emerging markets, and we've had to take into consideration, for example, the IP laws in Brazil and China, and Argentina, for example. And we have some difficulties, actually. We have had some difficulties with some of those. I mean, some things are simply not patentable in some of those territories, but are patentable in others. That doesn't mean to say that we won't release the product in those difficult to patent in territories, as long as there is a sufficient business drive to do so. But I think what we have tended to do in the past, and I'm not speaking on behalf of Syngenta. I no longer work for Syngenta. I'm now retired, so I'm speaking just as in a general way. But what we tend to do is to look at, when each product is coming along, look at it from a number of different aspects, including the likely intellectual property protection, but also simple things like, for example, the cost of transport, whether or not the product will be stable in particular environments and not others, which will enable us to actually put the product on the market in those territories. So it's multifactorial, really, and IP law isn't the principal thing, but of course we do have to have freedom to operate. As I mentioned in the first slide of my talk, it is good to have an IP position, but an IP position is not the only thing that provides you with a proprietary position. I mean, if you are willing to accept a sufficiently low profit margin, or if you are lucky enough to be in a first mover position, then you don't need a classical IP position, but you always have to have freedom to operate.
Great, thanks a lot, Joe. I have another question from Monique Simmons. We rely on so few crops as our main foods. How can we encourage forms of IP that encourage a greater range of crops to get to the market? Slight overlap with the last question. Lauren, do you want to take that one?
That's a difficult one. In my mind, that's a very difficult one. I am hopeful that we can encourage, I guess, that on from a couple of fronts. One, I do think that the companies that are so largely responsible for dissemination of seeds are feeling consumer demand for variety, and they see reward when a product comes across that's exceptional. I don't know, Adrian, if you have been awash in Honeycrisp apples where you're at, but that has been a phenomenon in the United States. The growers they're a little frustrated in some ways because they're difficult to produce, but the public is demanding them on a massive scale. That was a patented apple. That said, I'm hoping that the counter movement can also keep enough traction that traditional crops are preserved and the new varieties are available for those that want them. It is a difficult tension because to me the patent system is also expensive enough that it may discourage smaller entrants from getting in to protect a new variant or a new variety that they may have developed, but which, again, where they're a smaller entrant into the area. So I don't feel like I've got a great answer for that one. I think it's a tough space, and I do see that evolving consumer tastes, at least here in the United States, do seem to be driving a demand for greater variety.
Yeah, I think that's right. It's partly consumer education, but the main driver for having fewer and fewer crops is the scale at which agriculture is done now. Especially if you see in the Midwest and Brazil, the huge areas that are devoted to corn and soybean respectively. It's kind of the sheer scale of the industry that's driving this this focus on fewer and fewer crops.
Absolutely.
Yeah.
Great. Okay, I think we'll have one more question and then let Joe and Lauren get back to their days. So Dean Parry has a question, and Dean would like to know, hi Joe, what impact do you think Brexit will have on the UK legislation relating to agriculture? Will it align more with the US?
Well, I don't know the answer to that. All I can say is I hope not. Right? I personally hope. I think the European legislation is pretty good. I hope not, but I suspect it might is the answer to that.
Yeah, I mean, there's talk of food safety legislation being more closely aligned with the US in terms of things like poultry is allowed to be treated in ways that are not permitted in Europe, and I think yeah, it will be interesting to see how that goes.
Yeah, I mean, I think at the moment, the UK would say that its policy, probably is a science-based policy, or a policy which is actually risk-based as opposed to hazard-based, which is what the European legislation typically has actually, that's the route that's taken. However, the farm to fork strategy specifically mentions risk-based assessments as opposed to hazard-based ones. It may very well be actually, whilst we say that the food that we consume will be, there will be no change in terms of its safety. I'm sure that is the case actually, whichever legislation we actually go down. But I think the intention is probably to have more of a risk-based as opposed to a hazard-based assessment.
Okay, I've just got one more question here. I'm not sure anyone will be able to help you out, Jan. But Jan Prenesil asks, I do understand R&D challenge, but it is still quite often killed by regulation. We are working on the usage of nanoparticles, mixture of copper and gold. Unfortunately, nanosilver is simply a no-go. Any idea if it is feasible to ease nano level? I'm not completely sure I understand the question, Jan. I think I'll probably take that offline with you, and we'll see if we can help you a bit more. Do you have a sense of what Jan is driving at, Lauren?
I don't. I know nanosilver has several applications that are a little difficult. There can be some medical problems there. So now that's something we probably could deal with offline best.
Yeah, Jan, we'll correspond with you about that and try and help you out. Okay. Well, thank you very much, Joe and Lauren, for a really stimulating discussion. I've really enjoyed presenting with you, and particularly with the question and answer session, which I must thank the members of the audience as well. That was really, really thought-provoking. So thank you very much indeed for your kind attention, and we'll be following up with you. We'll send you a link to the recording, etc. And in the meantime, I wish you all a very good rest of your day, and please stay well and stay healthy.
Okay, thanks. Bye-bye, everyone.
Bye-bye.
Thanks, Adrian. Thanks, Joe. Be well.
Bye.